brief for the attorneys to do some research on the impeachment issue that had arisen during the cross-examination of Stephanie Murphy. Before we get to that,
short intro.
Over the lunch break,
we are back.
I was in my office doing research, as I'm sure you all were. I was notified by a deputy that an unidentified female had come to the lobby of the 9th floor of the Judicial Center, had said that she is a reporter and she had information about the case and that she wanted to meet with me. And my response, and my judicial assistant, if I wanted somebody in the room. My response to the deputy was that I can't meet with anyone, but that if there was information to share, we were starting court at 12:30, that she should come to the courtroom and identify herself to the deputies as the person who wanted to speak with the court, and I would hear what she had to say in open court. A couple of minutes later, the judicial assistant that is filling in for my usual judicial assistant came into my office and said that the deputy had called her by phone and said that the unidentified woman had said she would not appear at 12:30, and that was it. So I'm just making a disclosure of extrajudicial matters that happen. I can give you a minute if you'd like to talk with your client and your respective co-counsel.
I would certainly like to know what it was she had to say, and I would invite her to contact me. I would make a determination whether or not it was something that I thought was worthy of being brought to the court's attention and to the prosecutor's attention. That's all we can do.
State, you want to be heard?
No, thank you.
Okay. All right, then let's finish up this impeachment argument, and then we'll get the jury. At this point, I've asked for the jury to remain downstairs in the jury assembly room. Just it's more comfortable. The chairs are more comfortable. They can spread out. They have vending machines and so forth. So, all right, it's your objection.
So we got back really quickly. Someone identifying herself as a reporter contacted judge's office and said, I need to talk to the judge. I have information about this case. And the judge said, yeah, well, I'm not going to meet with you alone. You will have to come to court at 12:30 and present it in open court. She then called them back a few minutes later, stating she would not show up in open court. That's the extent of what we were getting. And Wendy Mueller and Harry Pottersbeard became members. Thank you so much. I'll put you on the board when I don't have Miss Cuddleface in my arms. Yeah. Well, she's a bit heavy. But, yeah, she's a little sweetie pie. She got the zoomies just before.
And specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame the issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation. And specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that that would be allowed to come in this case in this manner. I found no case law to say that that type of information could come in. But I also have objections to the manner in which this is trying to be done because, number one, Stephanie Murphy testified that the original petition for injunction had allegations of X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, this is like a motion to dismiss in criminal court where you admit a paragraph, you deny a paragraph. It sounded like she said that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for. But even if it did, I do not think it's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations. Court may recall, in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position. The fact that she mentioned 3, my position is it opens up the entire petition. She doesn't get to limit it to just the 3 she chose to mention on her direct because the state called her, they opened that door. It's before the jury, I'm entitled to rebut it and probe it for credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition where these things are alleged. This inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, and so that we're clear as to how I perceive this should unfold. She then never corrects the record, regardless of whether it's a violation of the code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client, where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe maybe perhaps putting a tracker on a car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly determined to show that she violated the code of conduct, which again, I do think I should be entitled to ask, but merely to show that the trial judge, I will ask her this question also, the trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt on that witness's credibility. I have 2 cases in particular in an effort to respond directly to Your Honor's request. No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the board, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982. They say in this case,
Citation, not the citation.
page number is.
No, the whole citation.
So the whole citation is 412 Southern 2nd, 965.
Thank you.
The court says in this particular paragraph, cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test a witness's perceptions and memory, and to impeach that witness. And they cite United States versus Williams, federal case, Judge White, 592, Fed 2nd, 1277, Fifth Circuit, 1979. Limiting the scope of cross-examination in a manner which keeps from the jury relevant and important facts bearing on the trustworthiness of crucial prosecution testimony is improper, especially where the cross-examination is directed at a key prosecution witness. More important, and they string cite a bunch of cases to justify that, more important, a defendant should be afforded wide latitude to demonstrate bias or possible motive of the witness to testify.
Yes, we did see the beginning. Anyone who came in after, apparently someone identifying themselves as a reporter contacted the judge's office saying, I have information regarding this case. I can come to your meeting in your chambers, and you can bring your clerk in there with you if you don't want to be alone with me. The judge replied, you can show up in open court at 12:30 and testify in front of both parties, which should be the correct answer. And they called them back and said, nope, ain't gonna do that. So is it someone who's trying to self-insert them in a case? We don't know. The defense lawyer said, please reach out to me if you believe it's important.
As she has. That's the Mendez case.
The witness they're talking about right now? No, that was his divorce lawyer.
And in that instance, the witness was a layperson. It was an appeal of the conviction for attempted second-degree murder of a police officer. The court reversed the conviction based on what I just read, Your Honor. I also have, Your Honor, Roosevelt versus State. It's at 42nd Southern 3rd, 293. It's a 3rd District Court of Appeal decision. It's dated August 4th, 2010, Your Honor. This was a conviction for a sexually violent predator and commitment under the Jimmy Rice Act. It was reversed. It was reversed based upon the main question on appeal is whether the trial court erred in allowing the state to impeach the defense expert witness, Dr. Natalie Brown, concerning 3 separate matters. So in Roosevelt, it was a professional witness. She was a psychologist. The state was allowed to cross-examine the expert about an email that she sent while serving as a defense expert several years previously in a Florida criminal case. The state argued this testimony showed the expert's willingness to tailor her testimony to favor the party who had retained her and was therefore admissible to show bias. Here's what the court stated. Our evidence code liberally permits the introduction of evidence to show the bias or motive of a witness. Included within the types of matters that demonstrate bias are those that relate to the interest of the witness, favoritism, and corruption. Dr. Vaccari's willingness to forge her interview notes at the request of the defense attorney could illustrate Dr. Vaccari's corruption as a mental health expert. Therefore, because this line of impeachment could properly relate to the witness's bias, we find that the trial court did not abuse its discretion in permitting it. The last case I have to cite for the court is Russ versus City of Jacksonville. It is at 734 Southern 2nd 508. It's the First District Court of Appeal, Judge White, and it was decided May 19th of 99. The court reversed and remanded the ruling for a new trial because the trial court committed an error when it denied the admissibility of information relating to the prior DUI arrest practices of the defendant's city's witness. So in this case, Your Honor, it was the impeachment of an officer.
He wants to ask her about
Turning to the merits of the
stuff she
appellant's
didn't
argument.
testify to.
Impeachment of evidence by the officer's prior acts. Turning to the merits of the appellant's arguments, the credibility, bias, or prejudice of witnesses who testify in a case, as well as the weight to be given their testimony, are a matter for the consideration of and determination by the jury. Where the credibility and bias of an officer is brought into question by virtue of that officer's past acts, impeaching evidence of the officer's past acts is admissible. As the Second District Court of Appeal explained in Mendez versus State, which was the first case I cited to Your Honor, quote, whenever a witness takes the stand, he by that fact places his credibility in issue. Cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test the witness's perceptions and memory, and to impeach that witness. The right of full cross-examination is...
It's because there was more allegations about abuse than she mentioned, which he want to bring in, and he believes that defense have the state has opened the door, and this is why he's arguing this now, because there's no case law saying that an attorney can be impeached with it, but there are other cases. This is one of the tediums. He has to cite all this case law so the judge can rule on it and said, well, there's a precedent to do it, or no, it doesn't apply.
Absolute.
Don't think about it. It's case law. It's what you do to put it into the record. If you're a lawyer, you know how it is. That's the same when we read these briefs. I always skip through when it's Brown versus Massachusetts and a long line of numbers, because it's just case law to show that there is a precedence.
And the denial of that right may easily constitute reversible error. I'll be happy to show you what the cases if you like.
I was familiar with Mendez and Russ. I'm well aware of those two cases. Those come up quite a bit. And Roosevelt, you've explained it. I'm happy to take them, but
Yeah.
it's up to you.
All right, so if the court's aware of it, I don't see any necessity. If Your Honor wants it, it's here for the court. My opportunity of Sixth Amendment right that belongs to Ms. Benefield to cross-examine Stephanie Murphy is restricted when the court doesn't allow me to quote the story that she told here today. And that's going to include, respectfully, Your Honor, my then being able to ask Ms. Murphy, so I can try to save time here for the court and everybody else. In fact, did Douglas Benefield make these admissions at his deposition when you were present? And I propose to tick them off one by one. The reason for that is the court may recall that Ms. O'Donnell asked Stephanie Murphy what she observed, not only when they did the first exchange and how pleasant Doug Benefield.
No, he wants to impeach her testimony that Doug Benefield was the bestest man ever, and she was in contention with him at their hearing because apparently you can't be pleasant at a hearing. He then want to bring in that Doug testified during that hearing that he shot a gun, punched a dog, and apparently threw a cat. I don't know, but that's what he wants in there. He needs a way to find to get in that Doug had the potential to be crazy. This lawyer said he was the nicest, kindest person in the world. That's why he want to impeach her with the knowledge she had from the hearing where she was present, where he said those things. Yes, I did punch a dog. Yes, I did take a shot. Yes, I did punch a hole.
Was, but she concluded Miss Murphy's testimony by having Miss Murphy opine what a gentle, kind, and decent guy Douglas Benefield was. And I have previously given Your Honor a written
There's a text message where he says punch.
Establishing the case law that says questions such as, well, did you know, Miss Murphy, that he admitted A, B, C, D? Yes, you knew it because you were present. Are proper questions on cross-examination. If the court disallows that, the court has abridged Ms. Benefield's right to cross-examination. And I might add, Judge White, in the interest of fundamental fairness, given her testimony, I should be able to ask for that.
State.
Judge, and I'm confused about exactly what's being impeached. So apparently, what the defense is saying is that because Stephanie Murphy said, during the time that I dealt with Doug, he never overly expressed anger towards Ashley. I guess that's a new one. So apparently that now opens the door to showing that she knew other things. The question to her was, during the time that she was dealing with Doug and Ashley, what was his level of anger? Not what had happened before, not what she knew before. So I'm not sure that's how that opens the door when I asked her what the behavior was during the time that she dealt with Doug. So I'm not, and that's a whole different issue than all the case law we just talked about. I do obviously agree with the case law that you are allowed to impeach under the right circumstances, under the law, if the matter is relevant to credibility. I do not believe that any of this is relevant to the credibility of this witness. I believe that the defense is merely doing this for obvious reasons, trying to get in the admissions of Doug Benefield, which I dispute that he admitted things the way the defense characterizes them. So just by virtue of the fact that they're stated differently, I would disagree with their statements that he made. So I think that is what the defense is trying to do by labeling it as credibility and an attack on credibility. I think even if an attack on credibility was allowed under such circumstances, the specifics of these items would not come in. The fact that Ashley Benefield's petition for injunction listed 3 things does not open up Pandora's box where he can then impeach on the fact that the defendant admitted to those things. The court has already ruled that the state can generally talk about what the complaints were, that they were denied, and that type of thing. That's what the state did, generally talked about what the complaints were, and then that it was denied by the judge. So that's what the state did. I don't know how that opens the door to this type of attack.
That's the problem, because she made a character judgment to put in. Doug was the nicest, sweetest guy ever. She never heard anything bad, which is a lie, because she was at a hearing where he admitted to doing certain acts. So if the state can elicit testimony about his character from her, why can't the defense? I'm not a lawyer, but I think that the state opened the door because they wanted her to say he was the nicest, sweetest guy in the world.
Very, very briefly, Judge Mann.
All right, so I think from the first moment I had a hearing before you in this case,
We don't know.
I have explained the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party, or the party in this situation that's the proponent, and I say, tell me every argument that's in favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it would just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on. All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's five senses. Their memory of that, their ability to recall, their ability to communicate, their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point for this particular scenario. So as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the Second District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case unrelated to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of contrary information. I find that it doesn't provide any basis for impeachment under the existing case law, and this may be the case.
Then you shouldn't have let her be a character witness. She's a fact witness. She became a character witness when you allowed the defense to ask her was Doug a violent man? But someone said that lawyer was interviewing this morning by a reporter. Which lawyer? And again, I don't know. And ending time. Yesterday they talked about ending tomorrow for the state. I don't know how many witnesses the defense is going to bring. I predict if they only need to get one in tomorrow, the jury will have it by Friday.
Case that says it does. All right. So are we going to bring the jury back in?
Yeah, yes.
Before you bring them back in, just so I understand, so I'm precluded from basing my cross on the
How can she be that when she's
failure to conform to the professional code of conduct? Am I likewise precluded from probing her statement that Doug was a gentle individual and that the complaint that was filed was unfounded? In fact, the court report played it back. That was her characterization, that the allegations by Judge Moreland were
I
unfounded.
sustained that objection. So, sustained. Are you ready to bring the jury back in?
Yes, but do we need the witness on the stand?
Yeah, I'm just asking right now,
Oh, yeah.
are you ready?
Yes.
Are you ready?
Yeah, I would like to first make a motion. I move for a mistrial. I move for a mistrial based on the court's absolute and consistent denial of Ms. Benefield's right to cross-examine, and at every turn, the court's ruling adverse to the defense, despite the fact that the court has, under the same circumstances, allowed the state to be able to pursue it. I think individually, perhaps, it could be argued that they don't reach the level of reversible error, but I think cumulatively, especially given the state of mind that the court displayed in writing the order denying the stand your ground, where Your Honor fully stated that Ms. Benefield was guilty, I think we are seeing the result of that, and we are being denied not only the right to cross-examination, but the right to a fundamentally fair trial.
Would you like to be heard?
Yeah.
Denied. You ready to bring the jury in?
Yes.
You ready to bring the jury in?
Yes.
All right, can you have Ms. Murphy step back in, please?
I like this judge, but I don't like him now because he allowed character witness from that lawyer, and now he's denying the other side to impeach her with her own knowledge from another. Just because it was in a civil matter, it doesn't. He was a gentle giant. Yeah, you knew him from a civil matter as well. Why is she allowed to say that? Yes, we are still on pink press. Here she comes. I would hate to have those things hanging down my arm.
All right, Ms. Murphy, if you could resume your witness seat. Ma'am, I will remind you, you're under oath. I also need to ask, did anybody at all speak with you about your testimony or the questions asked? Did you speak with any of the attorneys? Did you speak with any other witnesses about questions they were asked or the testimony they gave?
No, none of those.
Yeah, it's just to pet.
Did you watch any of the proceedings?
God, no.
Pull it up.
Oracle Cat, so far, this is the first witness that really had something. Yesterday, it was just opening statements and officers arriving at the scene. This morning, we had her mom testifying that she didn't know anything. And then we had her therapist testifying she didn't know anything. This lady knows everything until she gets asked by the defense. Then she gets really snarky. And the judge just made an unfair ruling, in my humble opinion. I don't know if you can discuss the case on Court TV. We haven't looked in the coolers yet. You would just say chip, chop, chip, and denied to everything.
All right, y'all can have a seat. Welcome back, everybody. Hope you beat the crowd for lunch. Did anybody discuss the case amongst yourselves with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No sound.
All right, everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is...
Objection?
Ooh,
So I'm sorry, Judge, was that overruled?
overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a
Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later?
Absolutely, I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
Is that weird that a witness asked for all the documents in the case? Hey, Fed.
Can we approach?
Yes.
What now? Stop rolling your eyes and smiling. Chris, that's why I don't get the state's motive is apparently that she wanted to be an alone mom, and that wouldn't happen with that report. But he was divorcing her, and I'm so lost in what the state is trying to prove was why she did it. We have no witnesses talking about their relationship being bad. We have no witnesses talking about her threatening him. We have no witnesses talking about that she said, if you're going to try and take my baby, I'm going to do something to you. I don't know.
So I would like to pass these documents to you and let you just take a look.
Yeah, the divorce attorney asked for the
Take your
case
time.
file. No, and they don't need to. They need to prove that she did it without being afraid of her own life. Yeah, but again, why would you then go and unalive someone? She was moving to Maryland with, well, he's moving to Maryland too, but not at the same house. Why would you go and say, well, instead of him finding out I just been stringing him along, let me put some bullets in him? That's the thing I don't understand. Yeah, but would she be the lawyer for the estate? Have they declared that? I don't get why she wants the case filed. That's what they said in opening statements, but they haven't talked about it since.
So I have a series of simple questions for you.
I wasn't there that year.
Reconsider whether or not the release of Dr. Broder's report was set for 3 days following.
No such thing
following
as a
the
normal
incident.
woman.
It was agreed with,
Do you want to,
no, I'm not going to
Answer
revisit
it.
that.
you can answer and then explain if you like. I'd like you to first answer.
I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after,
Okay.
and I can explain further if you want to hear more.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Okay. Now, is it not a fact that Dr. Broder on the 3 days following the event was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that
No, you don't try to remember everyone's vacation. Stop being that cutesy, I'm so smart. I don't like her. I have now determined I don't like this woman.
document in front of you contain emails between you and
Objection. Relevance.
who? Does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Dr. Broder was returning from his vacation on the 23rd. So if you look back
Not
through the emails.
not responsive to my question, Your Honor. She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
Also stating, you called for a yes or no.
Well, and that's why I'm saying she's, okay.
No, you called for a yes or no, so
Oh, okay.
your objection.
Is sustained. Got it. All right. So is the answer to my question yes?
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
Go ahead, ma'am.
And you still maintain after reviewing that the hearing was set for release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place?
Had he been alive, yes. On the 30th, not the
Yes.
23rd, which is what I think you're
All right.
confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
No.
Okay, this is not the letter that I sent. This is a draft of a letter.
Mhm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. That was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to
So
have
that-
a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
May I, Your Honor?
You may approach, yes.
Here's the transfer, here's the order. What is the date of the transcript?
Well, the date of the hearing was November 3rd, 2017.
November 3rd.
That was
And
not
you were
what he
aware that
asked
The
about.
order was entered for a period of 6 months, correct?
Didn't you hand this to me for me to look at?
Sure.
You just started answering, and when he gets you to a place where you don't get your snarky answers out, oh, I thought you wanted me to look at this. I'm sorry, I don't like her, and I don't think she has anything valuable to add. She seems like I can understand why she's a divorce lawyer.
Okay.
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
Right.
that was entered.
And
10 days later.
if you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece of paper.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
Mrs. Stein.
Let me pass to you, if I can, this document.
Did you see it?
I did not. I don't know.
I need you to show it to opposing counsel before you show it to a
I
witness.
thought she had a copy.
I couldn't imagine having an argument with either of the men or women who is lawyers or judges in this case. Jimmy is out hunting the birds. The birds escaped this morning.
Ms. Murphy, is it not a fact that you knew on September 18th of 2000 that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broder's report?
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd. Because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. It's 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of the psychological evaluation.
Which was not said on that day, correct?
I mean, the 23rd, which is what they're talking about in this email.
Yes.
Right, it was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Ms. Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that
Yes
Doug
or
did not
no?
really understand what was going on at this hearing, and Ms. Benefield was even chastised.
So if I get a restraining order, Jamie puts a restraining order on me. If I don't understand what went on at the hearing, I can break the restraining order. I'm pretty sure if you have an order against you that you can't contact her, you can't send her packages, even if you misunderstood it.
By the court for manipulating that system.
Well, thank
and
you
so-
for adding that. Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it. So enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told.
So
And
that's Frank
we had
Disney.
time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Ms. Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in
Okay.
family law court.
So
I don't
she
know what
vol-
she signed.
She voluntarily participated.
I don't know. You're going to have to talk to Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in a family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You don't
Ordered. What?
you're not aware of any commandment that either Mr. Benefield or Ms. Benefield participated in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation
No,
with the
she's
Manatee
my
County
boss.
Sheriff's Department.
Give me just a minute, Ron.
Yes, sir.
Please.
Are you asking for a moment?
Yes. Please.
Apparently, he was watching this lawyer out of Michigan who put all his files correctly, and then he effed it up, and he thought it was a good look. I hate this clerk. It's the chubby guy behind him. He's not allowed at his table. Reindeer. What? Jamie is Cinderella. She has an army of birds that helps her. Today, one of the dogs let the birds out. Who let the birds out? Chirp, 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 chirp. So Jamie is out hunting birds right now.
All right, one last shot at this.
Can I see the document?
Yes, same document I showed.
Yeah, but you're a pro.
The same
I
one.
just said
Yeah.
he had seen you do it. I think she's doing it at the defense table.
Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is
had,
the answer to my, well, let's get a simple answer. Is the answer to that yes?
I don't have the docket. So I guess the answer is I don't know what the docket says. All I know is
You
it was
did not
scheduled for the
know.
30th.
Objection, Judge Leonard, answer the question.
You trying to make this,
All I know is that that was supposed to be addressed on the 30th of September.
and were you not told on the 30th September that the only issue that would be heard was the
Objection,
domestic,
asked and answered.
was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong and that-
Objection, compound question?
and that the only matter being heard was
Objection,
not
compound question?
the domestic violence injunction?
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do you
emails.
have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case,
Objection, badgering.
What answer your question?
that the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That's all.
Don't be, sir, you have one more paper. Mr. Taylor, don't forget your paper.
I'd like to approach also, Your Honor, after the witness is issued.
All right. Redirect.
Because she's not a barred attorney. It was a
No
weird.
questions, thank you.
Can this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right. Ma'am, you remain under subpoena. As I said before, same rules on sequestration. So you cannot discuss the questions asked of you or your answer to anyone.
There was a ruling that he's not allowed to sit at the table, and he has a small
I don't think
table
that's the
to have his computer on.
All right. Mr. Jury, can you step out, please? I'll answer the legal question. Don't begin your deliberation to talk to anybody outside the jury. Don't do any research on people, places, things, or legal topics we've heard anything about.
Jury sent out again. They get the exercise in today.
You all can have a seat. Subpoenas for depositions and trials in the old days had to be procured from the clerk, which is obviously a branch of the court. That was changed many, many years ago to allow attorneys to save time and effort and money for everyone involved, where attorneys of record were granted the authority under the Florida Rules of Criminal Procedure to issue subpoenas for deposition and trial. I would imagine if we pull them up, and I'd be happy to take a look at it, I would imagine that the subpoena that was issued is for the court.
So now
I would have to look this up.
the state,
My position is when a witness is subpoenaed to court, and the reason I asked each and every time, can this witness be released? Because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether you were subpoenaed by the state or the defense is of no moment to me. I asked, could you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena.
Thank
The obligations regarding the rule of sequestration in Florida statutes applies to you. Thank you.
Thank you.
because they argued that the defense didn't put her under subpoena, but again, she was subpoenaed to court, and they have allowed them to say, yeah, we'll still have her under subpoena, but not this lady. That's why are they afraid of questions? Maybe. No, she wasn't smiling at the state before. She was smiling at either the court reporter or the defense table with the way her head was.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure. So now I would ask that the court issue a subpoena to Judge Moreland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Moreland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report, and my impeachment of Ms. Murphy indisputably is going to come from Judge Moreland's JA, who told Ms. Murphy in the emails that I handed her and showed her The only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else.
Victim's family would be ahead to the left. Am I back? I'm back. He tried before the case started to subpoena the previous judges, the divorce court's judge legal assistant, and wasn't allowed to do that. And now he says, I need her to impeach Mrs. Murphy, because Mrs. Murphy lied on the stand.
Else will be heard. In fact, I'm going to read for the record. I'm going to read the one sentence email that was sent.
The reason I'm going to stop you at this point is you're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense.
Yes.
Present at that hearing, when we stepped back into the jury room, was myself, a court reporter, Mary Ann Floyd, the general counsel for the 12th Judicial Circuit, Mr. Taylor, and Ms. Benefield. The state was not present. They didn't have an opportunity to be heard or know these issues. Now, the issues are being brought to light. In order for them to have a fair opportunity to understand the issues and be prepared to argue against whatever motions the defense may make, I certainly think due process requires they're entitled to notice and opportunity. I would do the same for the defense if there was some issue for whatever reason that I had considered in camera or ex parte for the state, and whatever reason the need for the privilege or confidentiality no longer existed, prior to having a hearing on that issue and requiring the defense to respond to it, I certainly think at a minimum, notice of the issue and an opportunity to be heard. So right now, they don't even have a copy of the order that I signed that you just quoted from, Mr. Taylor, and they have no idea what you're talking about because they've not seen that order because I ordered it to be sealed.
Yes, if the court will allow me, I'll elaborate. And I would like to read the email in particular.
The issue that you seek to have heard right now, I am happy to hear it. However, it is not a pressing matter. You seek to have a witness subpoenaed in order to present, I would assume, during your case in chief.
Yes, sir.
We could certainly address that issue at the end of the day after the state has had a chance to review that order. And I don't recall if the motion. No, the motion itself was public, but then we had the in-camera hearing, and my order was I sealed it.
Yes, sir.
So
we had the email chain also as an exhibit.
Yes, so the email chain is an exhibit. There were two exhibits actually. I can't remember what the other one was, and then we had my order. So I'm going to need to unseal those things so you can get copies of them.
I remember what the other one was. It was her prior testimony from the stand your ground hearing.
It was excerpts from the stand your ground hearing, excerpts of Miss Murphy's testimony.
Right.
That was exhibit 2.
Correct, saying what she said today.
Okay.
So the only thing, if I may, that I want to supplement today's record with is I showed Ms. Murphy an email dated September 18th of 2020 at 10:18 a.m. included between her and the judicial assistant for Judge Moreland. And it says the following: good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only matter being heard on September 30th is the injunction hearing.
And that is part of the email string that's one of the exhibits.
Yes, sir.
All right. So like I said, I don't think it's appropriate to hear this right now. I think the state has every opportunity and should be allowed to review my order and the two exhibits.
Judge, can I just be heard real quick?
I'm sorry?
Can I just be heard briefly on
Of
something?
course.
Now, or you want me to wait?
Go ahead.
Okay. I don't know if, because I'm unsure what Your Honor is referring to, because we haven't seen it, the seal. I don't know that any of the things that Mr. Taylor just showed to Ms. Murphy were ever provided to the state in discovery, which is one issue. We received a defendant's exhibit list that was unnumbered and in no particular order. It has 391 items on it. I spent more time than I should have trying to organize it in some fashion, and I do not believe that any of those emails were ever provided to the state in discovery.
Wrong.
If they were, I'm still speaking, sir. If they were, I would just ask if somebody could give me the name, because I numbered them, but it has 391 items on it, and it's some of them have multiple things inside them, and they're not named anything that you can understand. So I'm just asking that if in fact they were provided, if we could, the items that were shown to Ms. Murphy, in addition to what Your Honor has said, unseal, please.
All right. I'll let you two work on that, and I will look forward to having a Richardson hearing at the same time that we have the hearing on the defense request for me to reconsider my order quashing the mechanic trial subpoena.
This is it's getting a little spicy. Now they're claiming that they didn't get the evidence from the defense, and the defense kind of implied that they didn't get the evidence from the state if there was other emails stating that this hearing would be about something else. We get a dismissal just to make everything beautiful in this case. They were talking about that email said the only thing that we will be discussing on the 30th of December, 3 days after she did it, is a previous motion. It wasn't the strings evaluation report. That's what he had in his email. Murphy claimed that she was informed that they were going to discuss the strings report, and that the motive that she had been given from the state for the murder was that she didn't want that report released. So that's why they're discussing this now. Well, Rachel, this Murphy chick was what made it all confused, because she was constantly overstepping and editorializing every answer. She never answered the questions with a simple yes or no. She kept talking about, well, Doc this and Ashley that. And then when they tried to impeach her, she got really snarky. And now everything's up in the air, because are they going to call another judge's paralegal to say, I sent an email to Murphy stating that we would be discussing that, and then the defense wasn't given that email, even though Murphy claims she gave that to the state? Because that would be a Brady violation, not turning over all the evidence. Some might have lied, yes. It's from that in-court, in-camera meeting about the judge's assistant. So it was a special hearing where the state wasn't, I think, because there would be some trial
I
strategy.
just prepared and sent to the clerk an order unsealing the prior order quashing Vicky Mechanic's trial subpoena, unsealing the 2 exhibits that were admitted by the defendant during the in-camera hearing, and unsealing the notes and transcripts of the court reporter that was present for the in-camera hearing. I'll sign that right now. That'll should happen pretty quickly, and state you'll be able to get copies of that.
Murphy
we'll see
claims
if
she
we can
gave
Have
every
this argument
email
by
to
the end
the
of
state.
today or first thing tomorrow before we get started. On the defendant's request, or tennis motion to reconsider order quashing, and the state's Richardson hearing. Did you, or I can state the evidence. Yeah, do 5.
This is getting spicy now. But now that evidence should come in tomorrow.
There's one for the state, and one for the defense.
No, I think he made a wrong decision before, but now he's opening up for it. But the two lawyers,
All right, state, call your next witness.
they're fighting a lot. Well, according to Murphy, she gave the state the emails from the paralegal claiming that they were discussing other stuff than just the previous, that they were discussing the strengths report. She said, I gave it to the state. I don't know if you got it. It's obligation of the state to turn over the evidence to the defense. So that's interesting. So, yeah. Hey, ugly truckling.
All right, who's your next witness?
Oh, Detective Chris Gillum.
All right, go ahead and bring the jury in.
Yeah, they did that, but she also claims she turned over all the evidence to the state, and that evidence should pertain another email that he didn't have. So, and he claims he did do it, but this turned from no, it's going pretty well to that got really crazy all of a sudden.
Are you all going to see? Welcome back, everybody. You're finding your chairs. Anybody talk about the case back in the jury room? Talk about the case anybody outside the jury? Or do any research on any of the things we talked?
I would have talked about how
Says more.
disjointed this is.
State, call your next witness.
Detective Chris Gillum.
You saw this, the affirmative testimony about the truth, the whole truth, and the truth.
I do.
Yeah, I don't think she helped him, especially when she said the most
My name is
important
Judge
thing
Leonard.
was
Over this case, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right as you need. And just speak in a loud, clear voice and it should pick up everything.
Yes, sir.
Good afternoon.
Not that I have.
Please state your name.
Chris Gillum, Gillum.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
22 years.
And did you work somewhere else before for several years? How many years?
Yes, City of Palmetto Police Department for 12 years.
And what position do you currently hold at Manatee?
I am currently a domestic violence investigator.
And how long have you been in that unit?
12 years.
How, I said in that unit, but if you could just describe, does Manatee County Sheriff's Office have a unit for domestic violence?
Yes, we do. We have 4 detectives.
Okay. And where and how is that unit housed?
We are housed at our building is the 3500 block of 9th Street West is the actual address. And within our building, it's my unit and the crimes against children detectives as well.
Okay. Were you in that same position back in 2020?
He's a
2017 to
transplant from
2020?
Massachusetts.
Yes, it was.
Back then, did your department house child protection services?
Yes, at that time we did.
Okay. And explain that. Were they with you in the same area or how did that work?
No, they were on the other side of the building. We had our own area and they were on the completely opposite side of the building.
And were they actually employees of the sheriff's office?
Yes.
Did you do a lot of stuff with them together? A lot of investigations together?
The domestic violence unit, we did not, every so often, that was mostly the crimes against children detectives that worked with them.
And as a domestic violence detective, have you investigated violations of injunctions and that type of thing?
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues
That's
to address the violation. But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
All right. Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Okay. Generally, what were the circumstances without it getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
Right. And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Okay. Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
I think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, well, explain what you can do with it.
We can make a physical arrest in the case. There could be no charges filed in a case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest and
Sustained.
so you said Ms. Benefield was calling you asking about the arrest of Mr. Benefield.
Yes,
Okay. And what did you tell her?
that the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations,
Yes,
right? So, did she continue to call
yes, repeatedly, twice a week at least.
and speak to you personally?
Yes,
And what was her comments? What were her concerns?
it was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
At some point, did you decide to forward the charges?
I did.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay. And what was her reaction to that?
She was upset that he was not being arrested.
Okay.
Yeah, to me, that sounds like a very troubled victim. I actually was at a police station once where a girl was trying to report a stalker that she had a restraining order out against. And the officer just said, well, can't you just change your Facebook? She said, I have a restraining order. He's not allowed to contact me. He keeps doing it. Yeah, but they're so hard to find. So he can sit there and look like Kojak all day, but still, maybe she was concerned that a guy she had a restraining order on, nothing really happened, even though he violated it. Don't you have restraining orders to restrain people from doing stuff?
Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
Okay. At some point, did you speak to Ashley Benefield again? And she told you about a court hearing?
Yes,
Okay. Approximately when was that conversation?
around the first week of May 2018.
May 2018. And
It
what
could
did
be
she
that
say?
too as well, Sue. But-
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee County.
Okay, you just said arrest for a hearing.
Yes.
But arrest at a hearing?
Yeah, said that there was a hearing, upcoming hearing in Manatee County.
And was that hearing involving your case or something else?
It was something else. It was not my case.
Okay. Did you know that there was a hearing or there was even a court issue going on?
I did not.
So she told you there was a court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset, and At that point, I would call it a dramatic cry, hysterical cry started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
And did you in fact explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Her just kept requesting to arrest him. I said, this is not going to happen. And her tone turned from the crying to very aggressive. And she says, you will effing arrest him in front of the judge and I will make sure you do it.
What did you say to that?
I started pushing back a little bit and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge, and it's just not going to happen.
And what did she do?
I guess she started crying again and came out with a comment, something like, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
Which, again, is something a domestic violence victim probably would say if she was afraid of her life to a degree where she might take a pew-pew and unalive him. I still don't know if she did it or didn't. But to me, that sounds like something a DV victim would say.
And that hadn't come up in this phone call. That the phone call dealt with me arresting Doug in front of a judge. And then it turned to arresting, or not arresting him, and allowing me to let him kill her and the baby.
Hey, Wendy.
So that seemed kind of different to you
Yes.
than what you had previously been doing?
Yes.
Okay. How long did this conversation go on?
20 to 30 minutes.
Okay.
For up to that time, it's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No.
That's true.
And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed, and she let out like a screech or a high-pitched scream. And she says, I'll do whatever I have to do to kill my baby or keep my baby, you a-hole.
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
And tell me, what volume is this?
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
Why would it be impossible?
I couldn't get my voice that high. There's no way.
So it was loud and it was high.
Yes.
And she said, can you repeat what she said?
I will do anything I have to do to keep my baby, you a-hole.
You a-hole. And did she say a-hole?
No, she said the full word.
Okay. And after she said that, what'd she do?
At that point, I had checked out of the phone call, and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
And had you even spoken to Doug about custody of the child?
No.
Okay. Were there other detectives around you at the time of this phone call?
Yes, there were two other detectives.
And do you recall their names?
Oh, yes. Detective Patricia Hetrick and Detective Brian Moreland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
It's the same.
And at some point, how did the phone call end?
Ms. Benefield terminated the phone call.
And you seem to have a good memory of this call.
Yes,
And why do you have a good memory of this call?
because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
Thank you. No further questions.
Cross?
Just a moment, Your Honor.
To those who don't know her, this is Monday. Thank you, Wendy.
Afternoon, Detective Gillum.
Good afternoon, sir.
I want to ask you a few questions about report writing.
Sure,
Do they teach that to you in police academy?
sure. Back in 1989, they did, yes.
Okay, it's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20?
Okay. And over the course of a year, we're talking about
300 closed?
So are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times I did.
Did you speak with her on or about the 31st
I
of
was
May?
prior to that.
Okay, about the South Carolina injunction.
Yes.
All right. And just to be clear, we're talking about the same thing. There was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Ms. Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Ms. Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, a capias is
Objection.
arrest warrant.
testifying?
And
Sustained.
It's all hearsay.
What is a capias?
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. That was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Now, a month later, well, actually, several months later, on May 31st of 2018,
Objection, Judge. I called for hearsay, but I apologize, I wasn't finished the question.
did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Ms. Benefield,
Objection. Hearsay.
Sustained.
in the report, did you indicate,
Objection, hearsay.
Sustained.
did you write anything in your report in describing,
Objection, hearsay.
Can you approach, please?
hold on, let me have one more shot at it. Did you document in your report anything different than you told us here today about how you characterized Ms. Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
May I show him the report?
She's just like a cat. She's just laying here. Yeah, you're a good doggo.
Judge, can we?
Yes.
Well, she's super. I don't know what brand of dog she is. She's the four-legged kind, but she's super easy. She just wants a little loving. And it's nice that she wanna hang out on the table, and that she's small enough. You know how it is. Babies and small dogs. It works every time. Yeah. I don't know. It's my brother's dog. He's on vacation.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capias request, correct?
I did.
Okay. And you put the case on an inactive status.
Yes.
And I think you decided, as you told us, it would be submitted to the state attorney's office.
Oh,
That
she's
is correct.
pure. Hey.
Now, on June 5th of 2018, you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
Sustained.
What was his position with respect
Nope.
when you asked him,
Objection, hearsay.
Finish the question.
did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not a package had been sent to Miss Benefield?
Objection, relevant.
Overruled.
Can you ask the question again, please?
Sure. Did you make a determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
Did you make a determination of what the contents of the package were?
It was a T-set.
And was hazmat called?
Objection, Judge. Hearsay.
Sustained.
As part,
Did you say hazmat?
yes, sir. As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
any other agency to this package that was sent to Ms. Benefield?
Objection, hearsay.
Sustained.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt?
Objection, hearsay.
I'm asking him if he told Mr. Benefield.
Please approach.
Did you tell Mr. Benefield?
Can you please approach
This is going
Can you
all
please
the way down to
approach?
crap.
Oh,
the bench?
sorry.
This is really going. This is blowing up right now. Nej. Nej. Du skal ikke spise alt muligt. She want to eat everything plastic. There's a lot of plastic near setup. My gym buddy has an American Bull Terrier, and she's a small woman, and that dog, it thinks it's a lap dog, but it weighs 50 pounds or something like that, and it's just built like a tank. She can hardly walk it because it just drags her along. So something small and fluffy like this is way easier. She could, but I would have to pick a lot of plastic up after her. I don't know if the judge is overly differential to the state, but yeah, he's really bad at asking questions. Yeah, I have a female gym buddy, because then I'm sure I'm the one lifting the most. I can bench press more than she weighs. Yeah, some of them are weird. Yeah, then I don't have to pick it up. Good thinking.
I think the last question I asked you was, did you tell Douglas Benefield you could unfound the case if he sent you the receipt for the sending of this package of tea?
No.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
It was the tea set. The tea set she claims had the heavy metals in them. TLA, no, just more of
No, I don't
sidebar,
see anything about
sidebar,
Ms. Benefield
sidebar,
in this
sidebar.
supplement.
Okay, you did determine though that the package, once you got the receipt, you determined the date the package was sent.
Yes.
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the
Yeah.
same day.
But you also determined that the hearing on the injunction was November 3rd,
That
2007.
was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So
But at the hearing, Mr. Benefield was present when the judge announced.
yes, when he announced, but it was
Okay.
my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that TSET.
Okay, who is the lead detective in this case,
For which case?
for the homicide case?
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay. And do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day.
Yes.
All right. You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and
Sure.
see if that report isn't 16 days following your contact with Detective Warren.
No evidence
And when did you say I
anywhere
contacted
of
Detective Warren?
poisoning.
You contacted Detective Warren on September 30th, 2020 at 7:47 a.m.
Yes, I entered a supplement on October 15th, of 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020,
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Miss Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Miss Benefield's response. 2.5 years later, you remember the details of the conversation
Absolutely.
and exactly what she said. Quotes, you quote her.
Yes.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Nothing further. Let me just check. Okay, that's all. Thank you.
Redirect?
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time. Okay. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system, not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because I wasn't going to buy into it.
And so after she murders Doug Benefield, you thought it was relevant, obviously.
I thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren,
Yes.
correct? Okay. Thank you. No further questions.
Did Detective Warren direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
And 2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrested, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released from the subpoena?
Yes.
Sir, you're released from the subpoena, you're free to go.
Thank you, sir.
No, I'm sorry, Judge. You are. Sorry.
Detective Gillen. Hold on. Sir, you have not been released from your subpoena. The rule of sequestration has been invoked by the attorney. That means that you cannot discuss with anyone your testimony here today, the questions that were asked of you. With the attorneys, parties, anyone else. You can't talk with other witnesses about their testimony or the questions that were asked of them. You can't watch any of the proceedings that may be online. You are still sequestered pursuant to your subpoena.
Yes, sir.
State.
State calls Detective Brian Moreland.
Yeah, Stephen, he does it constantly. It's annoying. You should know better. Yes, he should. Yes, he should.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing?
Yes, ma'am. Hello, sir.
Hey, how are
As
you,
the
sir?
deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right. And if you just speak in a loud, clear voice right at the microphone, it'll pick everything up.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
Please state your name.
Detective Brian Moreland,
How do you spell both names?
Brian Moreland.
And we've had some testimony about a Judge Moreland. I just want to make it clear. Is there any relation between you and Judge Moreland?
No, ma'am.
What is your employer?
Manatee County Sheriff's Office.
How long have you been there?
Since 2004,
What is your current position with them?
I'm a crimes against children detective.
How long have you done that job?
since January 2011.
And crimes against children, is it known by an acronym?
CAC,
CAC. Okay. So if you hear CAC detective, that's what we're talking about.
that's correct.
All right. So you've worked in that capacity for several years. So you were working in that capacity between 2017, 2019?
Yes, ma'am.
Okay. What does the CAC unit investigate?
Any crime that involves a child, any crime against a child, I should say. Sexual abuse, physical abuse, malnourishment cases, things of that nature.
And we heard that your office, you share an office space with other departments?
Yes.
What are
The
those?
domestic violence unit is also in our office.
Okay. And back then, 2017 through 19, there was another entity in there with you? The child protection services, were they in your?
Oh, I'm sorry. Yes, DCF was in there.
DCF, okay. I apologize. The letters have changed over the years, so,
Obviously, yes.
all right. Did you do a lot of investigations alongside, specifically DCF or Child Protection Services, what I call it?
So being in a crimes against children unit, we often work very closely with other agencies, DCF especially. My job as a law enforcement agent is to investigate crimes, basically. The child protection investigators, their job is to protect the children and offer services when needed.
Okay. So they have different goals.
Correct.
All right. When there's an allegation of child abuse, just generally, what is the protocol? To who investigates, who gets the information? Like, how does that go?
Generally, a report will come through the abuse hotline. Law enforcement gets notified, and DCF or child protection investigator will get notified, assign the case, and go out. We usually do that in tandem. So we're all there at the same time. And like we said before, different goals.
Different
When we
goals, but
get
you're
there.
there at the same time,
That's correct.
typically? Okay. And sometimes reports can come in, someone can just walk into the station, correct?
Oh, yeah.
Or call or do something like
Yes.
that with the sheriff's
And
office.
if we get it first, then that deputy, whoever's writing that report, contact the abuse hotline.
Okay. So I want to talk about, well, first let me ask you about Detective Gillum. So you said you're with the domestic violence unit.
That's right.
Do you know Detective Gillum?
I do.
Have you worked side by side or at least in the
We've
same
worked in the
space?
same office for many years, yes.
Okay. And he just testified about a phone call that he had that he remembers quite well.
Yes.
Do you recall him having a interesting phone call?
I remember the phone call. Yes.
Okay. Were you sitting there?
We shared a cubicle wall, so we couldn't actually physically see each other, but we could hear, obviously, everything that was going on.
Okay. And did this seem like a typical phone call that he?
He
No.
seemed quite exasperated at the end of that phone call.
Okay. At the time, did you know who Ashley Benefield was?
Yes.
Did you later become involved with Ashley Benefield with reference to CAC?
Yes.
And around December 2019, were there several investigations that came in, started a series of several investigations that came into your department?
Yes.
Okay. So I want to ask you about the first report or the first investigation. About when was that?
Can I refer to my report?
Sure, go right ahead.
December 10th, 2019.
Okay. And generally speaking, what was the complaint?
Judge, based on prior motions and we,
Yes, sir. I understand. Oh, go ahead.
Thanks, sir. This investigation involved allegations of sexual abuse.
Okay. So sexual abuse, obviously of a child.
Yes, ma'am.
And who was the child?
Emerson Canny.
And who was the complaint against?
Douglas Benefield.
Objection. Oh, I'm sorry, withdrawn.
Is it the same objection?
No, withdrawn.
Go ahead, ma'am.
So did you get assigned to the case?
Yes, ma'am.
Right. And so just as a matter of procedure, when you initially, when Manatee County Sheriff's Office gets a case, you're not initially assigned right away, right?
No.
What happens before you get it?
Generally, what happens in cases like this is however we receive the report, whether it be through the hotline, whether it gets reported directly to the sheriff's office, a uniformed deputy along with a child protection investigator will go out to the scene. The uniformed officer will normally write the information down in a report, and that information gets filtered through our supervision. And if it needs to be assigned, it's assigned.
Okay. So theoretically, on this particular complaint, there had been some work done before you got it.
That's correct.
Okay. And then did you continue that investigation?
Yes, ma'am.
And as part of that investigation, was Emerson sent to the child protection team?
Yes, ma'am.
And what is the child protection team?
The child protection team is a state-funded team that, for
Same objection, Your Honor.
Sustained.
for my criminal investigations. Oh, I'm sorry. Sustained.
Next question.
Yeah,
Okay.
you
Did,
know it was sustained.
Did you talk to Douglas Benefield?
Yes, ma'am.
Okay. Did you also speak to Ashley Benefield?
Don't recall if I spoke with Ashley on that particular case. I believe she was interviewed already.
Okay. And what did you do with the case? Were any charges filed?
No, ma'am.
Okay. So I want to talk to you about the second report, and that was what date?
Report date was March 21st, 2020.
Okay.
March 21st.
2020.
Generally speaking, what was that allegation?
That was a physical abuse allegation.
Okay. Physical abuse against,
Douglas Benefield.
and the victim of that would have been?
Emerson Canny.
Okay, same parties.
Mhm.
And how old was Emerson at the time, approximately?
2 years old.
And again, the same question, had some things been done before you got the case?
Yes, ma'am.
All right. Did you continue that
I
investigation?
did.
And at some point, did a second complaint come in before you were finished?
On the 23rd of, so March 23rd, 2020. Yes.
Okay, so a couple days later.
Mhm.
And what was this complaint?
It was again physical abuse.
Phys- Different than what came in a few days before?
Yes.
Okay. Did you investigate those two things together?
I put them in the same report. Yes.
And what did you do with those cases?
No charges were filed.
And I'd like to talk to you about the third report. When did that come to MSO, or when did you get it?
April 5th, 2020.
Okay. And generally speaking, what was that allegation
Physical abuse.
of Emerson?
Yeah.
And by Doug
Douglas.
Benefield?
Yes.
And once again, before it was over, did you get another complaint?
On the 27th, another deputy responded.
Okay. And what was that complaint?
Again, physical abuse.
Same parties?
Yes.
Did you again investigate those two case numbers together?
Yes.
And what did you do with those cases?
No charges were filed.
At some point, were you a part of what's called a staffing?
Yes.
And what is a staffing?
A staffing is when the entities, as I mentioned before, come together and try to find a good way or moving forward a good way to protect the child.
Okay. And did you attend a staffing on this particular case?
The Pletford
The
case.
Benefield,
yes. Mhm.
yes. And as a result of that, were Ashley and Doug assigned to go to therapy with Dr. Broder, or not therapy, an evaluation with Dr. Broder?
Yes, ma'am.
Okay. Thank you. No further questions.
Cross?
Yes. Just a few questions for you,
Yes, sir.
Detective Moore. The cases that you referred to, I think you said there were 5 of them.
Yes, sir.
I don't want any details.
Okay.
Those cases have to be reported, correct?
Yes,
That's how they're initiated.
that's correct.
And would it be safe to say that in this case, the reporters, without any names, the reporters were,
Objection calls for hearsay.
Go ahead and finish your question.
reporters were not all the same?
That I wouldn't know. I'd have to go look.
Do you have the report with you?
I do have the reports with me. I
Why
don't
don't you?
know. I don't know if it's going to tell me who the reporter was. Whether
Clicking something over here. If you are, please stop.
I don't,
Go ahead.
I don't want to know names,
Okay,
okay? The names are confidential, are they not?
that's correct.
Okay. I just merely want you to tell us whether or not, in fact, the reporters were different individuals. Would you search your?
I can look. I don't think the reports
Yeah.
are going to tell me, but
Judge, I would object to hearsay.
He's not giving
Right
names.
now, the question is just,
Whether the reports were from different individuals.
It happened in 2020. I believe they had their daughter in 2019. I believe. '18. Okay. Now, late 18. I think he met the kid in the beginning of 2019 when she was 6 months old. I think that's correct.
so it appears the report on 12/10/2019.
I just want to, because we're in a bit of a delicate area, Detective, I just want to establish whether or not, if in reviewing your reports, you're able to tell us if the reports were initiated by different individuals.
By looking at my reports, I cannot tell you that indefinitely.
Did you at any time personally interview Ashley Benefield?
I honestly,
Yeah.
I may have. I don't recall if I ever interviewed Ashley. I know I interviewed Douglas quite often. Initially, when I get these cases, the
Did
Uh,
you, I'm sorry.
interviews with her were already completed. So,
Did you at any time personally interview the child?
no,
Someone was clicking on a pin or something. The judge said, stop it.
I don't believe I have anything else. Let me just check, Your Honor.
What does it matter? With this defense attorney, I don't always get
That's
it.
all, Your Honor. Thank you.
You're
I believe you said, with respect to, did you interview Ashley, that you said by the time it gets to you, a lot of times those interviews have been done.
that's correct.
And that would be by who?
Uniform.
Uniform. And then he asked, did you interview the child? Do you normally interview children?
No.
What is the protocol for children?
Forensic interviews are done by child protection team.
Okay. And so generally speaking, you wouldn't say you interviewed children?
No.
And was this child of an age to be interviewed anyway?
No.
Okay. No further questions.
Sir,
That's all.
can this witness be released?
Yes.
I'm sorry.
Can this witness
Yes.
be released?
Sorry.
Mr. Taylor, can this witness be released?
Yes.
Sir,
No,
you're hereby
by the
released from your subpoena. You're free to go. Thank you. Thank you. All right, members of the jury, we came back early. We went to an early lunch, so we got back a little bit early. It's now, I think, a good time to take our mid-afternoon break. It is probably end up being about 15 or 20 minutes. So you can go back in the jury room. You're free to use your phones. If you need to send or receive texts or emails or phone calls, just don't talk with anybody about the case amongst yourselves or anyone else. And of course, as we discussed,
especially
don't
when
do
hearing
research on
that-
people, places,
that
things, or legal
The
topics
state's
you've heard anything about.
cases
Stretch those
didn't
legs,
want
we'll
a
see you back in a little bit.
report out. I don't get that one. He has some bright moments, but he's also very confusing.
All right. Jury's out. You have a seat. State looking at the list in front of me. 1, 2, 3, 4, 5 more on the list.
Yes. 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 I have a question about that.
Yes.
So we've had Dr. Vega kind of on hold. And so I don't know how far we'll get with these next 3 witnesses. I can have him come here, but my question would be is if it was gonna take us past 5, if he comes, do we still do it? Because he's very busy and I hate to take up so much of his time. Or would Your Honor rather, because I know we wanted to deal with some other things, would you rather me tell him first thing in the morning? I know you don't know how long these witnesses are gonna come, take.
It's
I
your
can tell the court
witness.
that Dr. Broder is going to be up there for a while.
And so my question is, if I have him come, can we deal with him today? Or do you think once we hit 5 o'clock, if it's before him, you're gonna wanna go home? Which I understand either way.
Yeah, I would imagine that if it starts pushing 5 o'clock, we'll probably break and start again tomorrow.
Yes, sir. Okay. Okay, that's the schedule, that's all.
I haven't seen a witness list,
Okay.
but I believe they
I
said
do
they
have
had
something else.
3 or 4 out of
If you
state
don't mind. Not
witnesses.
as scheduling. So, the clerk was kind enough to unseal your order, but the items that were attached are evidently in that room locked up. And so I just don't know how we could get a copy because I haven't seen them. And so I just want to address it with the court of how to get a copy.
4 yes.
The evidence clerk is making copies.
Oh, good. Perfect. Thank you. Thank you, Judge. Thank you.
All right, anything before the break?
Right.
Yes.
Well, it's been a whole ton of sidebars. Both sides are still acting up. The defense attorney, I feel like he's getting worse. I don't know if it's just me, but yeah, I feel like he's. It's not. I liked him better yesterday. Well, it was those unsealed documents from earlier. Why are you wearing a mask and a raincoat? Well, weird people everywhere. Yeah, they didn't live together for 3.5 years, but they had an on and off relationship, marriage for 4 years. So it's gonna be. But the state, according to Murphy, their theory is she didn't want a shrink evaluation report released, and that's why she did it. Does that seem like a credible reason for her to do it? I I I I don't know. The police call, or the call to the police about why they didn't do anything about the RO. I would believe people in those kind of relationship would do it, but then again, why did you keep in contact with him? Why did you let him come to your house and help you move? There's, as you can probably tell, I'm very confused about all of this, where it's going, but we still have to give her all the benefit of the doubt. And the state haven't disproven that dog could be violent. I don't know. They lived in South Carolina, and then she moved down to her mom when she got pregnant. They had been together, moved away from each other, then got back together. He had a reverse vasectomy that she paid for. She got preggers. They had that ballet company. Around that time, she started to feel that the morning sickness and stuff like that was bad. So she moved with her to her mom's in Florida, and then at some point he moved after them. When we don't really have I can't give you a timeline in this case because he was supposedly in South Carolina while he was also reported standing outside in her driveway. It's a I'm getting more and more more and more confused. Did he not turn up? She didn't ask him to help move. Well, we have those text messages from the Stand Your Ground hearing. I believe we watched the text messages. They were daily contacting about that move. He kept sending her Bible quotes every morning, and he asked, "Do you need anything from this and that?" So it wasn't a surprise that he showed up. That's not how I interpreted those text messages. And we heard her mom say today that he had gotten his dream job in Maryland. So he was moving to Maryland too, not with them, but with somewhere in Maryland as well. And according to the text messages we heard during the Stand Your Ground hearing, there was nothing, stay away from me, you can't contact me, anything. It was apparently they had an agreement that he would take back his motion, his filing for the divorce, and she would take back something else. I can't remember what she had filed at that point. At that child or that custody hearing. Oh, sorry. That custody hearing they were supposed to have 3 days later. They were supposed to retract something. We haven't heard about it in this case. We heard about it in the Stand Your Ground. So again, we have to isolate it from this one. So yeah, Yeah, and he had been there, it seemed, every day to help move. I'm not sure, but I think I read somewhere that he rented the U-Haul, but I'm not sure. They were sharing the U-Haul that they were moving in. That's why she was saying she needed to pack her things last, because hers would come off the trailer first. Thank you, Jill. Yeah, I knew there was something about the U-Haul that either he rented it or they rented it. It wasn't a surprise that he was there. But I just, yeah. I'm just getting more and more confused by the witnesses. Well, did he follow her, or did he follow her child, his child? We don't know that, but again, she called the police and was afraid. But to me, it's still not a clear picture, and if it's not clear, then any reasonable doubt must befall her, because that's how the justice system works. Any reasonable doubt goes to the defendant. And if the state claims that she did it to keep a shrink evaluation secret, that's more stupid than she wanted the kid alone. It's well, most people are surprised when they get new holes in them. Yeah, you can use that, but there's always custody battles and divorce cases. What I don't like is how easy it is for someone to file SA, especially against children, claims against someone without anything happening. Because if it's not proven and he's not found guilty, shouldn't she be punished in some way? That's a charge that can ruin someone's life. So I don't think, let me be honest, I don't think the state have proven it. But I don't think she's a saint. I don't think he was a saint. But I'll take my personal view on both of them out the picture and just look at the legal matter. And that is, if the state doesn't prove it, she is innocent. I think both of them might have been a-holes. Both of them might have misused the justice system. But that has nothing to do with what we're here for now. We are here to figure out, did she legally do this? And the state's claim, they haven't really claimed anything that happened in the house. So it's going to be interesting with that doctor. I don't know what that doctor is there for, if that's the ME or it's a shrink or something. Yeah, probably something close to that. Yeah, she couldn't keep the report, and especially if you unalive him, that report would be looked into, because that would be used against you as evidence. So I don't get why they believe, because she doesn't seem like she's stupid. Well, you can't really, because everything would be self-defense. I never ever trust a jury. You're swinging towards DV by dog. I'm swinging toward Amber Heard like abuse of the Me Too movement. No, I'm not claiming he did anything towards her. I'm just saying I think both of them are a-holes, and I would, in my opinion, in my former marriage, if I had been in a house where my ex-wife had made a desk pop, I would probably be afraid of what happened. If she had thrown a loaded pew at me, might have felt threatened. if I had a tendency to knock our house pets out, I could understand if she felt threatened. But again, all of this has to be proven by the state. She could be the next AH. I don't know. I just know the state haven't proven anything so far, other than he stopped breathing around that date. And she admitted she helped him stop breathing. But the case isn't about DV allegations, SA allegations, anything other than when she did this, was she legally entitled to do this? And it's kind of like, again, all of us who've been hanging out for the last 3 months, it's kind of like in the Karen Reed case. They spent 7 weeks talking about the weather. They never, ever touched upon how John stopped breathing. This seems like building up that she was a bad person, and she might have been. In a divorce, both sides are bad people, if you ask the other side. She might have been an a-hole, and you're always an a-hole when you're a defendant, when the state pressure you. But what this case is about is this. Was this legal or wasn't it legal? And I don't think they so far have touched on the legality of her doing this. Yeah, because if they're not showing you something solid, reasonable doubt must go to the defendant. Again. Yes, could be. He was a widower. He lost his previous wife 9 months before he met Ashley. Nej, Molly. I have a dog that needs to be told not to bark. I think I have a pause thing. Hope you got a little exercise in. Yeah, she also accused him of poisoning his ex-wife. So I think there's a lot of again, I don't think any of them were good people. But again, that's not what the state has to prove. They don't have to prove if someone is a saint or a sinner. They have to prove if this was legal. And that's one of the things we should always remember when we're watching trials, because we want to put all of our emotion into it. But most cases are really simple. Can the state prove they did something illegal? And it has nothing to do that she has a resting bee face, that he was a jacked up CrossFitter, that his cousin seemed rather sus. It all have to do with this. Was that a legal movement or was it an illegal movement? Never pull a Megan Fox again. What's a Megan Fox? Being super funny and a good streamer. I can promise you I will never be a good streamer. Making jokes is not politics. No. As long as you don't go in and go too far. Oh, because I put on my exercise video. It's the only pause video I had, and it's an old one. I don't know why I had it. Yes, it was because which trial was it where the judge always talked about them doing exercises? I think that was a trial. Was that the Nicholas Mew trial where the judge always said, stand up and stretch and move around and do some. So that's why I put on the dance break. I'll make a new one. Well, postpartum, that hasn't been proven either. We are all sitting here and thinking we are the detectives. No, we're the jurors. The jury are not fact finders. They are not going around snooping. They just have to listen to what the fact finders have presented to them. And they can sit there and think, yeah, maybe she was postpartum 2 years after she gave birth. Maybe he did throw a cat at her. We don't know. But it has nothing to do with what we read in the papers or what we saw online. The state have to prove this was illegal. That's all. And I know it's really hard because we wanted, our minds want to fill the holes in this case. And there's a lot of holes. And that's why I'm sitting here and I can't decide. As I said, I think they're both were a-holes. And I bet you if I asked either side, the other side was the worst person in the world. But when it comes down to it, it's a simple movement. Legal or illegal. Hey, Ghost. Well, it depends. I've seen some bad juries. So, anything else? Anything else? Well, she had a bottle. She could do enough damage with a bottle. Yeah. At least follow up with her and say, well, I looked into it. We don't have anything to hold him on. But again, if he had an RO and he was, I don't know if he was contacted by a police officer in the neighbor's driveway when he allegedly was snooping on her. Shouldn't that be? But again, we saw in Canton yesterday that even though Kate Peters have ROs against boy, she wasn't made to move. And as I told my experience from the police station with that young lady standing there crying, and he said, yeah, just change your Facebook. Stop answering the phone. That's not how it's supposed to be. Yes, they are the finders of fact presented to them. Kind of like Sallyport videos that's inverted. They should see if that's fact or not. They are not investigators to search for facts. They are the ones who should look at what's presented and take what the facts tells them. It's kind of like Trooper Paul at a crime scene. They have to listen to what the facts tell them. But they can say, I believe this fact, and I don't believe this fact. They don't go out and investigate the facts. Mother of cats, thank you for becoming a member. I don't know, Molly has an idea that it's good to chew on stones. So I find a lot of stones in my carpet now. It's not good for her teeth. No, she's sleeping on the floor now. She want to have some downtime. The crime scene whisperer. Yeah, I know what he meant. That it was the crime scene team that talked to him, but he just misstated it. So the trier of facts. Yeah. Maybe she needs attention. No, she's fine. We just had a discussion about if she was supposed to yell at all the neighbors or she wasn't supposed to do that. She's not a puppy. She's 2 years old, and I have her for a week and a half. She's kind of good when I give her back to my brother, and then we start over the next time. So I tried that the last time, and well, she has a ton of toys, but stones are apparently the funniest thing to have ever. And leaving them so I can, it's worse than walking on Legos. Tip jar, book Stephen Fenner again. Grazie. Book him for what? Two years old isn't a puppy. She's a big dog now. She just had her, I don't know, you call it in heat period or whatever you call it. So she was very popular with the men.
All right, we're back on the record. State ready?
Yes.
Fitz?
Yes.
All right. Let's go bring in the jury.
Yeah, I think she's 2 now. It must be 2. I had her last summer. No, maybe she's 1.5. That's not nice, Marissa. It's nice when Jamie comes back.
I'm back.
Did you see what Marissa said?
I did not.
That's so mean.
Ellen.
I'll call Valhalla. Yeah, let's tell Jamie that so she doesn't get angry at you too.
All right, y'all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk to anybody outside the jury about anything about the case, or do any research on people, places, things, or legal topics you bring up?
No, sir.
Everybody says no. Call your next witness.
Staples Dr. Brad Broder.
Crete is an island. A lot of English people. Crete is a nice island.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Thank you.
Oh, sure.
Good afternoon, Judge.
My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. You want to be about 12 to 15 inches from the microphone, so you should probably scoot up just a little bit. Adjust this left, right, up, down. And just using a loud, clear voice, it should pick up everything. So you breathing.
Fair enough.
Bless you.
Good afternoon.
Good afternoon.
Judge, just for the record, we renew all prior objections.
Yes, sir.
Please state your name.
Brad Stephen Broder,
How do you spell your last name?
BROE.
This is the guy whose report she allegedly wanted to keep secret. So she must have called him in ahead of the other people.
DER.
What is your profession?
I'm a psychologist, clinical psychologist licensed here in the state of Florida and in New York State.
And how long have you been a clinical psychologist?
I got my PhD in clinical psychology back in December of 1986.
And when did you move to Florida? I think you said New York. You were in New York
Correct.
before.
I first practiced in New York and relocated here in the summer of 96. I was licensed here by February of 1997 and have been practicing here ever since.
Okay. And do you have your own private practice?
Exactly. I'm a solo practitioner.
Okay. Do you also do some, what I would call consulting work for the Child Protection Team or Child Protective Services?
Yes, I've been a consulting psychologist to the Sarasota County Child Protection Team since the summer of 1999, and several years later was hired as a consulting psychologist by Manatee Children's Services, which is their name for their child protection team. Pardon me. And recently have been contracted with the Fort Myers Child Protection Team. That's just as of this summer.
Okay. And can you just briefly explain what are your duties with reference to being a contractor for the Child Protection Team? What do you generally do?
Well, through the Department of Health, each county in the state of Florida is supposed to have a consulting psychologist on their team. And that is for several reasons. One, it helps out with supervisory cases if on an as-needed basis, as well as once or twice a year, there's supposed to be in-service trainings where you conduct seminars, do presentations to help the staff there. But primarily it's to attend the multidisciplinary staffings, which they're asking the consultant to come in and discuss a certain case, what might be going on, if you have any kind of impressions or recommendations. Based upon those kind of meetings, then sometimes the psychologist myself would be asked to conduct an evaluation.
Okay. And ultimately, were you asked to conduct an evaluation of Doug and Ashley and Emerson Benefield?
I was specifically asked to conduct psychological evaluations on each of the parents, both Doug and Ashley, but not their child, Emerson.
Okay. The child was pretty young, correct?
2 years, 4 months to be exact, during the time I did the evaluation in the summer of 2020.
Okay. So you started the evaluation about when? You said summer, but.
I believe it was June 1st to be exact when I first met Ashley, and the next day I had met Doug for the initial intake interviews.
Okay. And what was the general goal of these interviews? You eventually were going to report back, I would assume, to the entity that hired you.
Yes, each psychological evaluation is meant to be submitting a report with diagnostic impressions and recommendations based upon the data that's been collected. The evaluation is based upon whatever the CPT recommendation was, meaning referral for the recommended evaluation. In this case, Manatee Children's Services had specific questions about each parent.
Okay. So, and your evaluation is generally focused toward the best interest of the child. Would that be a correct statement?
Yes, absolutely.
Okay. So you said you first began this around June 1st of 2020.
That's correct.
Did you ultimately complete evaluations of Doug Benefield and Ashley Benefield?
Yes, I did.
Okay. And as part of this evaluation process, did you review documents?
There's a series of steps in any thorough psychological evaluation, which includes collateral data, which is both defined as interviewing other people as well as reviewing documents. Yes.
Okay. And did you do that? You reviewed documents?
I was looking at it and I'm thinking the blue one, is that thin blue line? And the other one with the color, I don't understand that. It looks kind of like half one for soldiers, but the other part I can't figure out.
If I may, I just brought the report.
This one looks like some police thing, and we have the yellow ribbons for soldiers, but the red and I don't understand it. Oh, that's ovarian cancer, this one. Oh, and the other one?
Reports along with me in case I had to refer to them. But yeah, there was
Sure.
a series of documents reviewed for each of them.
Okay, and we don't need to get into specifics about what the documents were, but you did review several documents for each of them.
I certainly did, yes.
Okay. And what is a collateral interview?
That's when I asked each person to give me a couple names of people that they think understands their situation best that I could contact and call and just do kind of a phone interview. If possible, obviously a face-to-face interview is preferable, but based upon where people are situated and located, sometimes it's just easier to have that telephone conversation. So there are certain people, like the people through Manatee Children's Services, that I was going to be speaking to, for example, Kimberly Griffin, who is the case coordinator. But in addition to that, I asked both Ashley and Doug for their own people that they'd want me to speak to. But then, of course, doing the evaluation, I have the kind of wherewithal based upon what I learned from them, if there are other people I need to speak to or that I believe I should speak to in order to get a more complete picture of the individual.
Okay. And did you in fact do that with reference to both of them? Speak
Yes.
to collateral contact?
Yes, I did. Yes.
Okay. Did you meet with Doug and Ashley and Emerson together or separate?
Given the structure of their family unit, I had multiple interviews with each of them individually. I had several interviews with them together, a couple of interviews with them together as the couple, but several additional interviews with them when they would exchange Emerson at my office, and when we would, kind of see how that the drop off or the exchange goes. But I had also seen each parent with the child both in their residence as well as in my office. So there were multiple interviews.
Okay. So this sounds pretty extensive. So how much time did it go on over?
Throughout the summer of 2020, I think the report was actually completed and submitted on September 14th of 2020.
So I want to speak with you about Ashley specifically. Did she ever show any hesitation about meeting you with Doug present?
No.
Okay. Did she act differently when she was with Doug meeting you, as opposed to when she was not with Doug meeting with you?
As I had indicated or described.
Why do you make people pay for you to interview them like it's not an appointment? I don't think he made them pay, the ones doing the evaluation, ordering the evaluation is paying for it, I think.
Described in my report, she did demonstrate or present with a different demeanor when seen together versus when I would just see her individually.
Okay. And when you saw the two of them together, did they discuss plans for going forward? And I'm talking about moving. So did they discuss that with you?
Ashley had made it very clear that she had every intention and desire to relocate back to her home state of Maryland. Doug had the impression that this was something that he too could do because he had some connections to the Defense Department and some of the work that he did. He felt he'd have more clients up there, so he was perceiving that as he shared with me, a fresh start that they could reconcile and be together in Maryland.
And when Ashley and Doug met with you together, did Ashley indicate that this was the plan, that they were moving all together as a group?
Ashley had no intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her grandmother had passed away and the mother had inherited the house. So they had their residence established. So she had that plan.
Okay. And so I guess I wasn't being very clear. Were they moving their items together, like same U-Haul truck?
And no, absolutely not.
Okay. So Ashley never told you that about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay. And when she was alone, she would indicate to you those things that you just described? Or
Yes,
did she indicate that when she was with Doug?
When she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were. It was, they weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. Child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson.
Okay. Did Doug, during your joint sessions, did Doug express in front of Ashley that his hopes that moving forward, this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that.
Not really. I think the closest she ever got to that was to kind of say, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She kind of deflected.
Yeah, because
That was
she
a
was trying to-
response, in my opinion.
yeah, they made it out to say like she was stringing him along and saying, yeah, we're getting back together in Maryland. That's what she stated in her opening statements, that she was putting him on and then in reality didn't want to do it. And now he's telling us she didn't give him any affirmatives. Again, something a DV victim probably would have said. If she didn't want to say anything when he's in the room, you would probably say some wishy-washy.
She said, hey, slow down. We'll talk about it later.
Yeah, let's just focus on Emerson right now.
Attention away from that.
And did she ever say in one of her individual sessions with you, did she ever say anything to you about she was running out of time and needed to move to Maryland or something like that? Do you recall?
Yes, we had that discussion in one of the sessions.
And can you just explain what she said about that?
In essence, she was very frustrated and concerned that
I'm going to object to, as I understand that he's called as a fact witness, and he's giving opinions.
No.
Okay, you can answer the question. What was it that she said about
Also,
the
you said
issue
to
of
be
running out of
truthful
time
if
and
you're
wanting to
afraid of
move to
them.
Maryland?
she was openly sharing with me her utter frustration with the sheriff's office, with CPT, with the court system, indirectly with myself, although she had also complimented me by thanking me for doing a quote unquote thorough job. But who was going to look out for Emerson, who was going to help Emerson, and she needed to do something. She needed this to be over with so she could get on with her life. She used the phrase, my life is in a shambles.
Okay. And did she make any statements to you about why she needed this to be over so quickly? Or why was it, did she feel it was taking too long? I guess should be my question.
He just said so.
But she certainly felt it took too long and she just wanted to get on with her life.
Okay. Did she admit to you that she was in fact going to marriage counseling with Doug?
She had been in agreement with them starting with a second marriage counselor, Dr. Quintel, after their attempts at marriage counseling with Sharon Foster had not worked out.
Okay, so she indicated that their intent to go to Dr. Quintel. But during the same time, was she still saying they would not reconcile, or she was saying they did want to reconcile?
I don't think she ever used the word reconcile when with Doug. She clearly made it very clear to me that she had no intention of reconciling.
Okay.
Well, there you go.
Yeah.
And
she did
during
lead him
this
on.
time, I would say the year at least before your meeting, did Ashley talk to you about doing things with Doug? And for instance, I'm talking about lunch and activities. Did she talk to you about that?
Throughout the time that I worked with them, it was very clear they were very open, sharing with me the things that they would do together, such as, for example, the hit movie that particular summer was the sci-fi thriller Tenet, T-E-N-E-T, and they had agreed to go see that so the grandma could watch Emerson. They have a quote-unquote date. They enjoyed the movie so much, but also found it kind of confusing and hard to follow that they agreed to see it a second time together and had a follow-up a date for that movie. But in addition to that, they had done other things. She would go to Doug's apartment complex where they could use the community pool and take Emerson into the pool. They shared with me that they had gone to the beach. She described in detail watching Doug, I think it was Father's Day specifically in my notes there, where she described how nice it was to see Doug playing with Emerson, playing in the sand with Emerson. And so then from there, they would go out to lunch or go out to dinner, sometimes with Emerson and the grandmother, sometimes without. So they were, throughout the time I was working with them, they were seeing each other.
Okay. Did Ashley ever talk to you about the birth certificate for Emerson?
Naturally, in this kind of evaluation, since it concerns a child, they talk about the child and the marriage and the relationship and see each parent with the child. So yeah, that came up. She gave birth at Tampa General Hospital and signed the birth certificate, Emerson Grace Caney.
And do you know whose name Caney is?
She wanted to keep her grandfather's family name, and so therefore she used that name.
Okay, so the child wasn't named Benefield.
Was not.
And
I went to school plays with my kid's mom. I have invited her to both my parents' burials. I have been at family gatherings at her house. Let's just say we didn't have a nice divorce. But every time we did something where the kids were involved, we played nice. And I've never, ever, whenever anyone said, aren't you sick of her? Don't you want her to jump into the sun? Said, no, I just want her to be the best mom my kids can have. Because my kids should have the best life. They shouldn't, because I'm a bad father or she's a bad wife or whatever the reason was, we didn't get along. So I played nice. I bit my tongue. I went to a lot of things I would never, ever have done if I didn't have my kids with me. Maybe she's trying to work something out so the kid would get a sense of family. And seeing Emerson being happy to play with him in the sand, you can still feel like you don't want to be with him. But I would always, to this day, when my kids are grown up and we are together at family gatherings now, my ex-wife and I, we are cordial to each other. We play nice, and I wish the best in the world for her, because I don't want my kids to suffer anything because anything happens to her. So again, I see a lot of hills made into mountains in this case.
Yeah, I agree.
I'm not the biggest YouTuber. I was the most viewed YouTubers 3 days, but I'm not the biggest YouTuber. No, they're interviewing the guy who did the psych evaluation on them. Exactly, because the kids shouldn't. I had a few people who wanted to badmouth her when the kids were around, and I put a kibosh on that right away and said, they don't need to know anything that went on in our relationship. I told you. Never ever speak ill around my kids about my ex-wife. I'll shit on her every second of the day when they're not around. But when they're here, she's mom. And moms are the best thing in the world. And we'll treat her as that, no matter how I feel. Yeah, well, we're not close friends. I can't stand her. She can't stand me. But we still smile and wave, boys. Smile and wave.
Did she ever put, or did she indicate to you whether she ever put Doug on the birth certificate as the father?
She did not. That became a point of contention with the two of them, things that they were discussing, changing the name from Emerson Grace Caney to Emerson Caney Benefield. That was an issue that they were discussing.
And did she ever admit to you that she didn't tell Doug that she was even giving birth?
She shared that she did not inform him.
Okay. And you mentioned a little while ago that she was frustrated with some of the agencies. I think you said law enforcement, the courts, that kind of a thing. Did she express why she was upset with them?
She felt that Doug was unfit to parent Emerson, that he was only using the child to get her back, to win her back, so to speak.
Okay. And these agencies, they played into that, or they didn't play into that?
What was described and came out of our discussions and the interview sessions was that she felt that no one was willing to step forward to protect Emerson, that they all got it wrong, for example. So when CPT evaluated the situation where she had bruising on the neck, she described to me that it was several days later, so the bruising didn't show up, and that went down as unsubstantiated, so it was never followed up on. And
okay, so she basically felt like they were getting it wrong. These agencies were getting it wrong.
No one was protecting Emerson. She did not agree with that.
During one of your last meetings with Ashley, did you have a conversation with her in your waiting room?
The day after, a day or two after the report was submitted on the 14th, Ashley showed up in my waiting room, unexpected, unannounced, and she wanted a copy of the report. And I had explained to her procedurally that the work product that I produce is then the property, in this case, of Manatee Children's Services, and had submitted to them. But I let her know that, she'd be able to get a copy through her attorney, but they did have to get a court order to release it. And that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt, she needed to know what was going to be recommended so she could move on.
Okay. And during that conversation with her, did she say anything that that struck you as interesting during that conversation with her?
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, as she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase.
Yes, the witnesses or the jury can interpret the credibility of a witness any way they like. and there's no rule that they must find everyone equally reliable or credible. So that's why sometimes when we're watching cases like that defense or divorce lawyer chick, when she started being all when the defense asked her, I don't think it works well in front of a jury. And she should know better. She's a lawyer, but she's a divorce lawyer. She's probably always fighting other lawyers, and that might have bled into this.
Phrased during that conversation that she would take matters into her own hands.
Okay. And did she express to you at that time about being frustrated about the timing, things weren't going fast enough?
By that time, she was, again, ready to move on, and she was frustrated with the entire system.
Okay. And did she make any more statements to you at that time?
Sorry?
Well, so she had a plan to go to Maryland and take it up with authorities up there. Like, that sounds like she had a plan with that.
Yeah. And
I mean,
again,
come on.
just she's stringing him along. She's not saying, yes, honey, we are going to make mom, dad, and baby the dream come to life. That's the thing. I didn't, I thought they were moving in together, but then her mom said, no, we were moving in together. And then, sorry, I can't remember who put it in, that he was moving up there, but she said, leave my stuff on the outside of the U-Haul because I'm getting off first. So he knew they weren't moving in together.
Mm-hmm.
So,
Not that I recall. Again, I tried to encourage her to be patient, that her attorney would definitely be able to get a copy of the report, and they could, work things out once they read the report, and they should be able to settle things.
Okay. And did she ever say what she would do if it wasn't fast enough?
No, I don't think she specified anything more than her desire to, again, get on with her life.
Okay. When was the last time that you saw Ashley? Was it that day that you're talking about?
When she came to the office unexpectedly, yes, that was the last time. Prior to that, the last time I actually saw them was, I saw Doug on September 7th, and then I believe I saw them together on the 10th of September.
Okay. And the last time that you saw them together, how did they seem? Did they seem the same as they had the times that you had seen them before?
Well, Doug too was becoming frustrated because he was viewing this as a fresh start, as I said. And
Okay, I'll move on. Did you complete the report for Ashley Benefield?
yes,
And how long was that report?
27 pages.
And did you do the same type of a report for Doug?
Yes,
And was it about the same length?
I think 24 pages.
Okay.
I'm sorry, 25 pages.
Okay. And I think you already explained this, but you turned your report over to CPT when?
September 14th.
September 14th. Okay. And then what happens to it after that is not in your hands.
It is, sometimes I find out, sometimes I get feedback, sometimes I don't. It's the work product goes to, in this case, Manatee Children's Services. And
okay. And did any of your evaluation or contacts give you any concern for the safety of Ashley or her child going forward?
Their original marriage therapist, Sharon Forrest, had concerns. She certainly expressed concerns, yes.
Did you have any concerns? Well, let me ask you this. Did Ashley Benefield ever say to you that Doug physically harmed her?
No.
Okay. Did she present you to you as being fearful for her own safety at the time she was having sessions with you?
Her concern was all about the safety of Emerson, not about herself.
Okay. Thank you. No other questions?
Excuse me.
Cross.
Give me just a moment, Your Honor.
watch-out trials, you have to take that up with the HR department. I'm told when to be here and what to do. Right now, There's nothing really in the pipeline. If this ends by Friday, we might. There's a case that started now that we might do, but I have to look into it. I have my Snoop team. Always, if you have a good case out there, if you know a local case that's only shown on a local TV station, please reach out to me, and I can set my Snoop team on it. I think next month, September, I might. There's a 14-year-old girl who pew-pewed her mom in the face 3 times. I might cover that because the judge ruled yesterday that that cameras were allowed. So that's what I have in the pipeline right now. Oh, and maybe Corey Richards is supposed to go. No, that's in August. Yeah, next month is August. Corey Richards is supposed to start in the end of August. So
Like the actual trial, finally?
I think so.
Oh, okay.
Maybe.
It feels like forever with that one.
Yeah, I want to know what happens to Sleeveless.
Oh my God. Okay, I'll never forget that.
Thank you, Medita.
Dr. Broder, good afternoon.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has wound its way through to where we are today, and it's encompassed prior proceedings, has it not?
Yes.
Okay.
Yes.
And you've had occasion to sit for a deposition in this case,
Yes, correct.
and you've also given previous testimony.
Twice before in the
All right.
dependency
Don't
case.
tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him to kind of go along with him.
Yes. In your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So, for example, if she didn't particularly want to be in
Another objection. Another sidebar.
Goodness.
Sidebar. Ba, 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 sidebar.
Are you gonna make a
Sidebar.
new
Sidebar.
AI song now?
No, because I can't put in. Please make it like the Batman theme, because you can't use. I tried something, not the Batman theme, but I might have said something else. But no. Again, what did we learn from this witness that said she wasn't afraid of him? We learned that he appeased him. We learned she appeased him when they were together.
Mhm.
Strung him along, didn't give him any confirmation on anything, but wanted out of the relationship. Can we? I don't know. Jamie, do you have a good grasp on this case?
No.
Oh,
I
I
missed
feel
most of the
I'm.
afternoon, but I'm still not
Yeah.
feeling it.
Yeah.
I'm not hearing anything that's just like, got her.
No, and that's my problem because according to them, this is number 1 out of 4 or 5 witnesses they have left. We're probably going to see a medical examiner too.
Mm-hmm. Yep.
And the testimony from the divorce attorney that they were in contact with was she wanted to hide this report. This report isn't damning to her. She wanted out of the relationship. She wanted to move to Maryland to get away from him.
But she like signed off on the report to like let it become public. So if
Yeah.
that was the case, that makes no sense if she's trying to hide it.
No, and that's the thing I don't get. This report isn't that bad.
No, it's really not. A lot of people do have Irish. I've had friends in those situations. Oh, Molly.
Yeah, but again, there's this duality I can't get my head around. She want to get away from him. Can you come over, help me pack my house? I could understand if she had said, my mom and I are packing around the house. Can you take Emerson for a couple of hours?
And maybe he was insisting on coming over and helping. I mean, we don't really know.
Yeah.
So
I
I
don't
think
know.
you told us, Dr. Broder, that this policy of appeasement was designed by Ms. Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to.
Yes, to placate him. In other words, to not set him off.
She knew that she wanted to reconcile, so she wanted to kind of, I think, feed into that, so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
Did you acknowledge during the course of these evaluations that the signs were there, that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Well, let me ask you this. Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly consider that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
The abuse complaints, without giving me names,
Mhm.
they were initiated by more than the same person, correct?
Correct.
In fact, there was.
Objection, yourself.
Finish your question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct.
And 2 of those sources were professionals.
Sustained.
She expressed to you, did she not, real frustration with the system and its responsiveness to her situation?
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and, yes, establish residence separate and apart from Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal, yes.
All right.
Because they're not allowed to go into the previous hearings that has been in this. Actually, he was the guy who made the motion to get that in there. They have to refer this as a previous motion and not talk about the content of a previous hearing and not the content of it.
Are you familiar in your practice with domestic violence?
Yes,
Have you treated it before?
I've assessed it and treated it on occasion, yes.
Did Douglas Benefield, from what you learned as a result of your involvement in this case, exhibit
Objection.
Go and finish your question.
symptoms consistent with the domestic violence abuser?
Sustained.
Give me a minute, Your Honor. I do have one other area of inquiry, if the court will allow me. Did you find anything aggressive about Ashley Benefield?
No,
Did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
well, that's two different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
You in fact concluded she was a good mother.
Yes, I observed her many times.
That's all. We'd like to keep Dr. Broder under subpoena.
Redirect.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No further questions.
All right, doctor, at this point, we're done asking questions. However, as you've heard, you remain under subpoena. The witness sequestration has been invoked in this case by the parties, so that means you cannot discuss your testimony or the questions asked of you with anyone else,
Right.
including the attorneys.
Okay.
You can't talk with any other witnesses about what their testimony was or the questions asked of them. And to the extent there may be anything online about this case, you're not to review it or watch any of it. All right, so remain available in case they need to be recalled.
Just point of clarification, remain here today or be ready for tomorrow or what?
So you're released for now. Just if one of the parties reaches back out to you during this trial period, you will need to report that.
Understood. Very good. Thank you.
All right, State, call your next witness.
State calls Dr. Jason Quintel.
She accused him of SA and I think CA against the kid. No evidence of it. Dum, 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 dum.
She's on Sarah for testimony, have to give you the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Thank you.
Hello, sir.
Hi there.
My name is Judge White. I'm presiding over this.
Oh, you
case.
didn't say
As
hi
the deputy
there.
may have said, just make yourself comfortable in that chair. You end up wanting to be about 12 to 15 inches from the microphone. It adjusts up, down, left, right as you need.
Okay.
If you just speak in a loud, clear voice right into that microphone, it'll pick up everything.
Okay, great. Thank you.
That's who I thought about.
Good afternoon.
Hi. Sorry, I spilled water.
Blue Carroll.
Please state your name.
Dr. Jason
Did
Quintel.
you hear him?
How
He
do you
goes,
spell your last name?
oh, I
It's
just spilled water.
QUINTAL.
What is your profession?
I am a mental health counselor
How long have you been a mental health counselor?
since 1998.
And where's your office?
My office is in Lakewood Ranch, off of State Road 70.
And how long have you been there?
That location we moved into in 2018. Prior to that, we were on Lena Road from 2008 on, and then prior to that, 2006.
And at some point, did you become familiar with Doug and Ashley Benefield?
Yes,
And when was this?
that would have been in 2020.
And do you recall about when in 2020 that was?
They came in for their first visit as a couple's visit on 7/15/2020.
Okay. So we heard from Dr. Broder, he was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and Ashley.
Okay. And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay. I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
During the first session, they talked about, yes, they wanted to work things out.
Okay. When they were together, did they indicate they wanted to get back together, like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley.
Very few of them, but some are very smackery of delivery.
Mm-hmm.
And thank you, Watch Out Trout, for becoming a member.
Welcome.
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
Ask the question. He's entitled to complete his answer.
Oh, now he wants
so
to.
did she indicate she still wanted to reconcile with him when she was with you alone? Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation, and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay. I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yeah, she thought that that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay. The last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but.
Maybe Thursday, Friday. I can look if you need that.
No, that's okay.
Okay.
And about what time of day was it?
I believe that was a morning session, 10:30-ish.
Okay. Did they say Dr. Broder's report was done?
I don't recall them saying that the report was done. I know that they had been waiting on it and it was supposed to determine specific things for how they move forward.
Okay. And did they indicate when they were going to court next?
I do not know that. I don't recall anything mentioned about when court was.
Did they indicate to you when they expected they were going to have access to that report? Excuse me.
No, I don't. There was not a when the report was going to be released. It was going to happen at some point.
Okay.
My understanding is that they still had plans to move to Maryland.
Okay. Thank you. I have no further questions.
Okay.
Cross.
Afternoon, Dr. Quinto.
Hi,
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Objection, Judge.
Sustained.
Not gonna get into this.
Okay, without? Yeah. Oh, you have no idea. Without,
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out? Remember, please don't begin your deliberations. You can use your phones, but don't talk with anybody outside of the jury. And don't do any research on the people, places, things, or legal topics you've heard anything about. Dr. Quintel, I'm going to excuse you to the hallway.
Okay, take my
the-
stuff with me.
Yes, sir. The rule of sequestration has been invoked.
I don't even know what that means.
That's on my.
Okay, sorry.
What that means, you don't have to see, what that means, sir, is that you're not to discuss your testimony or the questions that have been asked of you here in the courtroom. It also means that you can't discuss other witnesses' testimony, and that's with anybody, or the questions they were asked. That's with the attorneys, other parties, witnesses. It doesn't matter. You can't discuss anything that's gone on inside the courtroom when you've been in here. Also, that I understand this may be online, and you are not to watch anything online until you're released from your subpoena, or the jury has been released from its duties.
Okay,
All right, so
sounds great.
Thank you.
Thank you. Thank you.
Mr. Taylor, is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe
All
that
right.
you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made. From the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break and we'll be back.
Did I miss
missed
what
it.
exactly what he did?
A bio break.
Well, all I
You
know
missed
is
everything, Jamie.
he told the jury to leave and then was like, I feel like those lawyers, I feel like I'm gonna get a whooping. I was like, wait, what happened though? What did he say?
and you are not to watch anything online until you're released from your subpoena.
Keep going back.
Or the
That was one of
jury
his
has been released from the
questions.
students.
Okay.
Also, thank you.
Oh,
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
Not gonna do this.
Okay, without. Yeah, oh, you have no idea. Without,
Why don't you go ahead and
oh, that's why.
Mhm.
sustain?
Not gonna do this.
okay, without. Yeah, oh, you have no idea.
You don't say that in the courtroom. That's just stupid. You're 74 years old. You should know better. No, because the witness was like, psh, and he said, yeah, you have no idea, in a condescending tone that the judge said, well, I read it as he believed the judge isn't fair. So that's stupid. That's really stupid to say something like that.
Well, he got yelled at.
Yeah, he got told off. But again, do you think the judge, even though he's a big sports fan and an umpire, gets more fairer or less fairer after that?
And I thought he's been okay.
Yeah, but when
So,
you say something like that, do you think it
yeah, don't
helps you?
test the waters.
Yeah,
Don't push buttons.
it's yeah, and again, no matter what he meant with it, you just don't say it. It's kind of the same thing with which case was it where there was constantly remarks made? Oh,
Well, is he
I can't
saying
remember.
you have no idea to the judge, or is he saying you have no idea to the objection the attorney made? Like what
No,
was it
he
about?
said you have no idea because the judge ruled to the objection, and then that guy said, and smiled, and he said, "Yeah, you have no idea." So what he meant was, yeah, it's really hard to get this out there, and because the judge shuts me down. It's like the
Yeah, I
Edgecombe
don't know.
case, where what's his name, Ivory Lamar, constantly made remarks too, and that was Judge Borowski. So that wasn't that intelligent either.
Okay. Well, he just said about the remarks, and before he said it, she objected. So that's why it made
Yeah,
it
but
seem like
there was because
he
he
was
isn't
saying it
allowed.
to her.
He's not allowed to talk about the gunshot, and that's why he said objection, and then he made his ruling, and then the witness said, and he said, "Yeah, you have no idea." So, especially with a jury in the room, you don't imply that you are shut down by the judge. And but it was the same with Ivory. He tried to do all these little tricks, and Borowski just tore him. And then he made his paralegal a witness, and he didn't he try to claim that the immigration lawyer was racist as well. Yeah, he did. That was a fun day.
Yeah.
No, that smile was like, this is ridiculous, in my opinion.
I think it was just he's nervous because he's knocked over his water like twice already.
Yeah. No, it's not. It's not potential mistrial stuff, because who rules on mistrials? It's the same judge who ruled if he should exclude himself because he was ruling over the stand your ground hearing. It's the same what we see in the Karen Reed trial. When everyone is saying, well, it's going to be a mistrial. No, because Bev is the one who's going to rule if it's a mistrial. You'll take it up with the appeals. Yeah, he started by spilling water, so he's a good one.
He did. And then he spilled it again after the whole fiasco.
Yeah.
I was like, get it together, guy.
Yeah, and that's how it always is, because the state didn't really want him to talk about, because it felt like she didn't like the answers she got from him either.
Yeah.
Yeah, it's probably closer to contempt instead of a mistrial.
I would say. If that, yeah.
Well, Eddie, I think they have tested him so much today that he wanted to put his foot down. That's why I think he did it. And both sides has been. That's the funny thing, because both sides are idiots in this case. He's constantly forgetting to say he want to keep people under subpoena. Then the state starts arguing if their subpoena can be used by him, which it always has been, just because they don't like them recalling the witness, that Murphy chick. It hasn't been a problem. Then they start objecting about that, and then he has to do a ruling that he believes it's the court's subpoena, it's not the state's subpoena. So I think he's just. If I was him, when we're done today and the jury is sent home, I would probably give them a stern talking to. So yeah.
Mm-hmm.
Yeah, and there's a lot of hearsay and there's a lot of crap, and they know the rules, and they have ruled on this pre-trial, and they still try to get it in. And once or twice, yeah, you can try and sneak a fast one, but when it's constantly, as a judge, I was also sit there and say, could you please don't do that? State slightly open that door. Yeah. Yeah, it's but again, we don't normally see this level of well, we can watch the Young Thugs trial. That's kind of the same, with lawyers constantly saying bad stuff about each other. But I feel like today I would have snapped too.
All right, let's round up Dr.
Yeah.
Round up.
Quintel. Get him back in here. As he's coming in, I want to remind both sides that the court has made a number of rulings over the last couple of months regarding the admissibility of certain evidence. Until those decisions and orders are revisited and changed, it is the responsibility of both sides not only to operate within those bounds, but also to advise their witnesses of the prior court orders and admonish them to stay within those bounds. All right, go ahead and bring in Dr. Quintel. All right, welcome back, Doctor.
All right.
While you were outside, did anybody attempt to discuss the case with you or speak with you? Or did you speak with anyone at all about your testimony or the issues we talked about?
I did not speak with anyone. There was a reporter that came up to me, but I didn't engage with him or interact with him.
All right, did that person ask you questions?
He said that he knew I couldn't talk, but here's a card. I said, I don't want that.
Okay, all right. Anybody want to follow up questions about that? All right, everybody says no. Let's bring in the jury.
Oh, God.
Maybe it's the reporter
All right, y'all
from
can have a
earlier.
seat. Welcome back, everybody. Anybody begin deliberations, talk or communicate with anyone outside the jury about anything we've talked about, or do any research? All right, everybody says no. All right, Mr. Taylor, you may resume your cross-examination.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
Well, it would be relevant to understand.
All right, you approach.
It would be beneficial to understand the relationship if he reached the conclusion that he was abusive. I understand why the state doesn't want that in there. So
Oh, yeah, of course.
yeah, weird. Did you hear that reporter after lunch?
What?
A reporter called the judge and said, "I have information about this
Yeah.
case. I want to meet you."
Did anything ever happen with that?
No, he wasn't. It was a she. Didn't show up.
No. Come on. If you have information, just let it
Yeah.
out. Let us know. We want to know.
Yes, you stand out of the spec for the jury. Yeah, I can understand why. I can understand why the judge is getting mad because, again, isn't it relevant to understand how the? Imagine if he says they had a lovely relationship. Doc was the perfect husband. I never ever saw him portray any nasty feelings or emotions or anything towards Ashley. She, on the other hand, was very, very vindictive.
Yeah. And maybe she is, but
Yeah,
still, this is still about self-defense. Has nothing. This isn't a DV case.
yeah. She called the paralegal, well, the judge's assistant, and said, "I won't show up for open court." So that's what came from that. So she refused to because he said you can appear in court 12:30 in front of the two parties, and she said, "I ain't gonna do that." I just want to hear someone says grounds.
I don't miss that.
Didn't he
As much
stand
as
when
I think
they
of it.
arrived? Normally witnesses are called after the jury is in there. So I would think everyone stood because they are the highest of the high in the courtroom. I don't know.
Maybe he forgot.
Yeah, he seems like a guy who gets a little bit of the wacky tobacco.
Oh my goodness, come on.
Bum 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 ba-dum, bum 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 ba-da-dum, bum bum bum. Do you know what the worst thing in my gym is? In the men's locker room, they play elevator music,
Ew.
but they take kind of like 10, 15-year-old songs and turn them into elevator music. I came in,
No.
well, this might be older. I came in today and there was a elevator edition of the Cop song from Pitch Perfect. La da 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 dee da 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 da
Yeah.
da 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 dee da 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 dee da da.
I
And I'm
don't like
standing there.
that.
trying to get hype. Well, today was cardio day, so I really tried to get hype. But night, Molly. But listening to the cop song in that version, it's so annoying.
Mm-hmm.
Yeah, but when they turn the cop song, I should do a pause video with elevator music. When they turn
Did you?
the cop song and the other day, what was it? It was "Born This Way" by Lady Gaga. It's also da 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 da. Jesus, it's annoying.
Do not like that.
I
Um,
am not muted.
what are you? Baker, you muted. What kind of video are you going to make?
A pause video, because I played a pause video and people got angry
Oh.
because it had workouts in it.
I thought you said a horse video. I was thinking you're going to go prancing.
Why would I make a horse video?
Prancer size.
Well, at least he didn't do Botox. But she looks like my kids when they were small and tried to cry.
Did you make any inquiry, doctor, about why Doug Benefield would want to stay in this relationship? You can answer.
Can you repeat the question, please?
Yeah.
Thank you.
Was there any observation by you in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're going to have to recall you, so I'm done.
Redirect? No. All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one or both the parties may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony with anyone, even the attorneys, any other witnesses. You can't watch anything that might be online or read any news.
No interest in anything of that anyway.
You're free to go now. Thank you, sir.
Have a good rest of your afternoon.
You too, sir.
Thank you.
I want a chair like the witness chair. It looks comfy.
It does
My
look
back is
comfy.
killing me. I'm having a massage tomorrow.
Good. You do that.
Yeah, I need it.
We approach about scheduling.
Okay.
You just were up there.
What?
Yeah, that's the big thing. No one is released. Well, the first day, everyone was just pew, 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 in and out, and now everyone from well, the only two who hasn't been, well, no, the daughter was kept under subpoena, but her mother and who was the second one here today? I forgot already.
All right, members of the jury, the next witness may take quite a while, so instead of keeping you so late tonight, the attorneys and I have agreed it's probably better if we just come back tomorrow morning and start fresh. So I'm gonna let you go for now. If you would please, say tomorrow time. Are you guys okay with the time?
Who's the next
All right.
witness?
Once again, plan, what would we say today, 8:45? And get you up here and hopefully get started right about 9. So let's do the same thing tonight. Please remember, no discussion amongst yourselves. Talk about the weather, nothing else. Don't talk about the case with anyone outside of this jury. And don't do any research on people, places, things, or legal topics that you heard anything about.
Yes, sir.
Okay?
Yeah.
We'll see you tomorrow morning. You too. Take care. All right. Thank you all. We'll see you tomorrow morning.
Just before we, sorry. When you unsealed, we got the copies of I got the original order that you did, and then the clerk provided me the transcript and the emails. I think you said something, when you said transcript, was that the transcript you're referring to? Because the court reporter hasn't transcribed what happened.
Correct. I sealed, if you look at my order, I sealed her raw data, her notes, and any transcripts.
Okay, so I was gonna ask her to do it, but I wanted to clarify before I did something wrong.
I have not requested it. I don't even know if one has been done, but it has been unsealed if there's one.
Thank you, sir.
Does your order, Your Honor, allow the clerk to give them a copy?
Yes. Everything's been unsealed.
Now I think they're done.
Yeah.
Well, that was a heck of a day. And I still can't remember who the second witness was. Who was the second witness? We had her mom, and then we had some.
We had, didn't we have her mom and then her therapist?
No,
Yeah, her therapist
No.
was there today. What?
no, yeah, that chick she lived with,
Yeah.
who looked like she aged horribly since the pre-trial hearing. Her hair
Yeah.
was really weird, and then we had Dr. Murphy, and then everything turned to crap.
Yeah, and then I was in and out for the rest of it, so I don't really know what happened. I'll have to rewatch it or something.
Yeah, but the therapist, then Dr. Murphy, then a couple of agents from Child Protective Service, and that guy from DV who said, "Yeah, I don't care." And then we got to Dr. Smarty Pants, and everything just turned to mush. Yesterday, everything there was a lot of sidebars, but it moved. Today, it just seemed like it's been a slog with every witnesses. It's because the therapist believed that it was bad for her mental health that she would be living on in cheap hotels with her daughter. That's why she moved her into her house.
Mm-hmm.
So that's the reason why. Yeah, his divorce was that was Murphy, and she was a piece of work. Yeah, we had all the crime checks yesterday. That's correct. But interesting day today. I still have absolutely no idea what went on in that house that night. I think she will have to take the stand and convince us she did nothing wrong. in my opinion.
I kind of feel like that too. But I don't know. With the way I'm seeing the state going, they really
Yeah, but
don't have anything,
self-defense
but it's
cases,
like,
if they don't hear from them, they
I know, but also they can really make the case look bad too. So it's a tough one.
yeah. But yeah.
She could go
Uh,
up there and be so unlikable, and then everybody's like, "Yep, she did it." I don't know. It's tough.
Why didn't Kara have what? Karen, not Kara. I'm tired again. No, I don't. Again, we're back to normal scheduling. I don't have any feelings in this case. And it's going to be a little short one, so I don't have to get angry. Even the Adam Montgomery trial, a guy I would punt into the moon, the sun, run him through a wood chipper, and then paint a wall with him. I ended up saying the state didn't prove their case against him because they didn't, and I hated them for letting her go. So, yeah.
And I love that we always have someone in our little group, Sue. She is not on our side whatsoever.
No.
And I enjoy it so much.
The last case, it was Sean who was against us, I believe.
Oh, I don't
We have had great success was against us, but I like it when people don't agree on things as long as they keep it civil. And people are doing that, and that's good. That's a good thing. And again, if you find someone a little bit too crash, I think you can push those little dots next to their name, just mute them, and then you don't have to see them.
Mm-hmm.
I've seen so many parents misuse the court system to keep the child. This is reeking of just that. There's a real DV victim, and she's not one. She's a manipulator, straight up guilty. Oh, I have a poll up. Very. I don't see it the same way, and that's fine. And the reason I don't see, well, I do see her misusing the system, but I just don't have the state proving that she intentionally took his life. And that's the big.
Yeah.
Because I think, as I said 20 times so far, I think both of them were kind of assholes.
I think he did some stuff, and she's done some stuff, but we don't really know. That they are the only people that know what really happened.
Bruce, I have you blocked. I can't see what you're saying.
You blocked him?
Yeah. It's always okay to have a different opinion, because if we are all sitting in an echo chamber, that's not that useful. Right now, not guilty 37%, hung 33%, and guilty 28%, 159 votes.
Yeah,
that's the perfect way to end the segment. Jamie, have you called all your birds?
Was I bird wrangling today?
Yeah, that's why you didn't came back after lunch, because one of the dogs let all the birds out.
Well, I don't keep them in my house.
No, you keep them in an aviary. Exactly, YouTube user. Even though we might think she is a massive C word or something, I don't feel the state have lifted their burden, and then she's innocent. And
yeah,
but I can't get to grips with it. But I still think to be found not guilty, you have to take the stand. I always need sleep.
We'll see.
But Jamie, I think I'm gonna get out of here. I'm gonna chuck Molly out in the garden and see if she want to do a little night toilet, and then I'll go and see if she want to sleep with me tonight. Tomorrow we'll start around the same time, and hopefully you will join us. Do all the things and all the thingy things. You know the drill. Ciao.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%.
100%.
Correct.
Checking your heart. So you literally built a cannon?
Yeah, it's pretty awesome.
Go
right, I'm in love.
back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.